Welcome, I'm Russell Alexander. I've been a lawyer with the team here at Russell Alexander Collaborative Family Lawyers for over 20 years. Without further ado, let's get into today's topic. On hearsay and text messages, the warning by an Ontario court in a recent case was straightforward. Family litigants need to be wary when including text messages and emails in their affidavit evidence. In a recent case of Hillier, the parents were in a custody battle over their 3-year-old child. The father, who was the primary residential parent, brought an urgent motion to have the child returned to him. The mother had been withholding the child from him, even though she was only entitled to restricted access under a prior court order. She accused the father of having a substance abuse problem and justified keeping the child because, based on her observations at a recent access exchange, she concluded he was drunk or at least had been drinking when he took the child. The father denied this, and in his affidavit materials filed on the motion swore that he had not been drinking that day. His own mother, with whom he lives, also attested to the same. According to the mother's affidavit, she called the police that night, and they had apparently confirmed it was clear that he was intoxicated after attending at his home. Problems with these assertions that under Canadian law of evidence, this was actually hearsay evidence. With narrow exceptions, the mother's affidavit evidence should have stuck to what she actually knew, saw, or understood that day, not her view of what the police thought or said. This is in keeping with Rule 1419 of the Family Law Rules, which expressly provides that an affidavit may contain only information that the person learned from someone else if the information source is identified by name and that person signing it believes that the information is true. Faced with the mother's impermissible affidavit, the court used the opportunity to lament what it called the unfortunate trend of inadmissible hearsay evidence being included in affidavits. It noted that as long ago as 30 years, in another case called the Santee, the court struck out the exhibit to the wife's affidavit that was not the proper format and consisted of a lengthy prose statement that was clearly pejorative to the husband and consisted of hearsay. The court in that order case wrote, "There has been a disturbing tendency in recent months to attempt to incorporate in motion material renditions of statements allegedly made by the parties or other sources without their inclusion in an affidavit. The rules, however, require evidence on a motion to be by way of affidavit. The basis of that requirement is obvious. Without the possibility of testing an allegation through cross-examination, there is an incentive to swell the evidence freely with unsupported statements by persons not clearly identified, and therefore safe from inquisition." That is the situation with this exhibit. The court in the more recent case of Hillier ruling upon those admonitions and observed that the same sort of thing was going on in the present case. But the exasperating factor that the hearsay could not include both text messages and email. The court said in the present case, the mother appends as an exhibit some text messages from the father's girlfriend that the mother submits shows the father had been drinking on the occasion in question. The mother makes allegations about the father's alleged history of substance abuse. The difference between today and the days of the older case is that the use of electronic communication as a tool of injecting inadmissible hearsay evidence into an evidentiary record. The lesson from Lisanti has withstood the test of time and remains the law today. Litigants should remain vigilant, ensuring that motion material is restricted to admissible evidence. The temptation to append as exhibits to affidavits, text messages, or email strings from third parties who do not swear to their truth must be avoided. The mother's exhibits were therefore inadmissible. For family litigants of all types, the court's suggestion to be vigilant in avoiding inadmissible hearsay evidence is a good one. To learn more about this case or to read the full article, look for the link below. Please leave your thoughts and questions in the comment box below. If you like this video and have found it helpful, please give us a thumbs up to let us know. You can also subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching today. I'm Russell Alexander.